Hey everybody, it's Mike Shea again, Transworld Business Advisors. This morning I've got Bobby Lean Law. Bobby's in my BNI group, and I wanted to, in light of some feedback I've been getting from business owners, current business owners, and I think this is something that future business owners, in my client base need to think about, is how PPP is going to affect how they operate. Not PPP, I'm sorry, how the pandemic COVID-19 is going to affect how we operate and how we protect ourselves as business owners from our clients and our customers and protect them at the same time, and what the liabilities are. And you got to talk to a lawyer to know how to protect yourself from a lawyer. So I figured I'd get Bobby on the phone because they have a wonderful way of figuring out every angle to defeat an argument or what you think you have covered. So Bobby, give a quick history of yourself, an overview of your firm, and then we'll get right into the topic about this nasty virus that's turned our world upside down.
Excellent, thanks. As Mike said, I'm Bobby Lean Jr. Lean Law is my firm. I've been in Florida since about 2012, came down here for law school, been around the ins and the outs of the employment world, federal and state-wise, and opened up my civil practice not too long ago, specializing in certain things, but our topic of discussion today is going to be, mitigation for small and mid-sized business owners, mitigating some risks associated with the pandemic, and certain other expansions of federal laws that up until recently, the small and mid-sized businesses didn't have to worry about. So anyway, before we get started, any type of, legal stuff, the video we're making today is for informational purposes, does not create an attorney-client relationship. Please don't use this as legal advice, just friendly, practical advice. And I'm sure Mike will have a comment on that disclaimer. We're attorneys, we have to have it, and we created it. So,
well, it's funny you do that, and I do it in all my communications because that's how, as a business owner, you have to think. You have to CYA, and I'll allow people to formulate their own conclusion on what that acronym is, but you have to CYA everything you do, and assume that sometimes the people who have the, that you just come across have the worst of intentions, and will use whatever you do say or how you do and say the right thing or the wrong thing and use it against you. So, which is kind of, perfect segue is this topic. It's how's this bug that we had nothing to do with, how am I responsible for what, a 1099 real, like, for example, I'm a 1099 subcontractor of my firm. But, under employment law, I can't be told what to do, when to do, or how to dress, right? Then I transition to a W-2. There's a whole myriad of things that the law is being crafted around today. So I'll let you kind of run down that path of, what's the best way owners and buyers of businesses, when they're running their businesses, need to protect themselves.
Sure. So we'll start with kind of a broader overview, as far as, how to open up in the wake of the pandemic. You're going to have a lot more forethought, or should have some more forethought, in negligence portions. Now, it's not typically something you think of in the employment scheme, but are you going to have enough PPE for your customers and your staff to feel safe? On the other hand, where is that line between being safe and reasonable and bleeding over into not being safe and reasonable, and that becoming a kind of a negligence action? So the quickest and easiest example would be a slip and fall, right? So there are certain types of instances where the say a shop owner would be responsible for a slip and fall. If, say, soda pop ran over, and there was soda pop on the floor, and it was there for a long enough period of time that someone in the shop owner should have seen it, cleaned it up, put out a wet floor sign, what have you, and they didn't. So then Joe Blow walks by, slips and falls. Now you've got a negligence lawsuit on your hands. So I foresee quite a bit of similar suits, right, between just customers and even employees for negligence claims as it relates to your use of PPE, hand sanitizing stations like that, and what steps the employer and the company have taken to protect everyone, right? So where's that line? Nobody knows, and that's kind of unfortunate right now, right? What I've been telling my clients now is basically just use common sense. I think there's a lack of common sense, especially when you're thinking about legal things, for no other reason than you want to do what's best for everybody, but you also don't want to put yourself in a position where you're spending too much money on PPE. It's not cheap right now at all by any stretch of the imagination. But it's all about your cost benefit analysis and your mitigation of your risks and exposures. And talking to an attorney who understands both of those things on top of the legal ramifications of certain things is certainly something you would want to do, especially outside of this video or anything else, if you're worried about those types of situations.
Well, I think, it's funny, 60 Minutes did a thing on Amazon on Sunday night, and Amazon takes a series of protocols. There was a union element to it up in New York where, they're claiming they were putting footage, battling, the saber. They, and then the operational head of Amazon took them through all the PPE. I mean, it was insane, the level of work they were doing. Conversely, then, 60 Minutes got some expose video showing everybody sitting in the cafeteria not observing the 6-foot rule. And, I go back to how you started off this call with this. Okay, let me read my disclaimer. The business owner has to downshift into neutral and take every approach to a customer. And I just took a note when you were talking about this, like, okay, I'm going to add a disclaimer to my emails stating, hey, you get to dictate as the customer how you want to interface me. If you want to interface with me face-to-face, we're going to observe standard protocols. It's going to be 6 feet. I'm going to be wearing protective gear. We're not going to shake hands, that type of stuff. And for, we were talking in my firm this morning about if and when we open up the physical offices, those with multiple entrances and exits, we're going to decide who goes through which doors. Customers come in, what exit point, what access point, are we going to have them sign disclaimers? It's a little, to what degree? Now, you and your profession, more is better, but then the business owners, to your point, have to live in a world of practicality and what's the competitive environment at, and yet protect themselves and their assets from the risk, because there will be PI attorneys who are going to use this. I was shocked that 60 Minutes went that quick. Now, I'm not surprised the platform. I'm not surprised what side of the agenda they were on. But I was like, dear Lord, that was fast. And I've already started to see ads from certain attorneys about work stoppage and who can they sue and what insurance company they can bleed. I think business owners need to wake up and understand that the legal profession is a business and they make money by suing and getting hours. So they couch it, some couch it in the reality. There's good attorneys and bad on both sides of those veins. I tend to facilitate and hang out with those that kind of are the, defender of the fatherland type scenario.
Of course.
Self included. And conversely, there are guys who are going to go, you blew it. You didn't. So that's kind of what we're talking about. Like, what's reasonable, and how does an owner know what reasonable is?
Well, so to kind of go back to what I've said, common sense is going to be your best guiding post. But from a legal ramification standpoint, me thinking as a plaintiff attorney representing someone who is going to bring some of these claims, my biggest obstacle, I would think, is not only proving that this person actually has the disease or the virus or what have you, and that has created some type of damages. I mean, that's kind of all up in the air. That would be kind of hard to prove anyway. But I think your biggest hurdle is where you pinpoint how this person got the coronavirus or the COVID-19 or anything going forward. Are you going to bring in the necessary experts that it's going to cost to investigate from point A to point B this poor person's life 24 hours a day for the requisite amount of time to meet your burden of proof, which is a preponderance of the evidence, which is a legal term for more likely than not.
Right,
That,
but at another level, the first question that gets hit from as a defendant is, what's your insurance company, right? And then it becomes a business decision. And most of these things never see trial.
right, of course.
And it's about
And
the cost of doing business. And I want you to kind of talk about, we're talking about common sense, but business owners don't live in this world. Like, I've been through a lawsuit, so everything I do is couched in that experience and understanding of how the lawyers pivoted to try and get to, and it wasn't about getting the trial. It was never going to get there because it was a bad case. About creating stress, because that gets you to the table to settle, which is basic negotiations. And most business owners, God bless them, don't ever get to this scenario where they get sued. But, people can die from COVID. Actually, they don't die from COVID. They die from the ancillary effects of COVID, which impacts other issues. But, that's how PI suits get settled up. It's like, what did he lose? And what was the damage to the family? And all these other garbage. Goes to a jury trial and they weep and moan and it's never practical. And then to your point, how do you prove it? You're in a better position to defend against the proof by having all the PPE, all the procedures documented and ready. And I guess what I'm trying to say is the best defense is a great offense. So you got to get in front of them now, so that when it comes after, you go, look, I had signs. I freaking had an overhead speaker system that said, hey, we're observing this. You need to make sure you wash your hands, right? We piped it in the sound system. So when when that attorney who's suing you goes, wow, I'm going to have to prove that this guy was not listening, didn't see the big red sign, the stand-up PPE device in the front door as you walk in wasn't visible. We're not relying upon a little cup, right? We're relying upon, they've got a 7-foot sign with a big jar of PPE that's a 55-gallon drum that says, wash your freaking hands. How do I prove against that, right? So owners need to go to that extreme to play defense.
right, of course. And to that point, no one thinks like this. We do. Well, I do because I'm a lawyer, right? The end game. What do I have to prove to a group of strangers? What do I have to show to a group of strangers, a jury, that the business did everything that it could? Well, anything that you can show that they can understand, right, is going to be a lot more credible, for lack of better terms, than something that they don't understand. If you can show, here's the sign, that's this huge sign that said XYZ, here's all the masks that I had, here's proof that they were there and that they were, either in use or you knew that you should use them, all your hand washing stations. People understand that. People can identify with that. What they have a hard time dealing with is this medical expert who's going to come in here and say, well, this is where they got it. And here's how they got it, because of, we took these cultures and we took swabs and it was present and prevalent. And
it's this part per million, right? They're not going to get that. But if you're a defendant and your security camera of your bay, so I own a Taco Bell and I've got video on the cloud that shows signage on the door. It records the voiceover, hey, observe to wash your hands, keep your 6 feet. It has the markings on the floor to delineate the 6 feet. And oh, by the way, there's a hand washing station 3 feet in when you walk in the door. That's a stand up. And you ignored all of that as the guy who's saying it's their fault. A picture's worth 1,000 words. So
absolutely,
you have to kind of dumb it down and defend yourself in such a manner. I mean, you've seen an email from me, right? In the bottom of my email is this huge disclaimer saying, blah, 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 blah. And it's all designed around, I'm not giving advice, right? I'm not a fiduciary. I'm not an accountant. I'm not a CPA. That's why we do it. And that's why you stopped and said, hey, purpose of this video, I'm not doing it. Right? It's to defend yourself just in case someone decides to do something stupid and come after you. And business owners need to be aware there are people who do this. There are people who drive around and make money out of ADA suits, right?
Yeah. They make a lot of money, to be honest with you. Yeah, you're absolutely right. You hit the nail on the head. Picture is worth 1,000 words. And again, it's also important to know what your insurance policies say and what they cover, because here's what's going to happen is, business owners are going to go out, and the savvy ones, or really the ones that are going to be worried the most, are going to go out and they're going to spend money talking to lawyers and trying to figure out XYZ on how to do to protect themselves. But not all of them are going to review their policies. Not all of them are even knowing what their policies have or have an updated copy of their policies. And that's an important distinction, mainly because, most insurance policies, commercial policies, have a duty to defend clause, right? So they're going to pick the attorney, they're going to pick the firm who's going to handle not only negotiations, but ultimately litigation if it goes to that route. Also, there are some policies that have the coverage that they would actually pay the claim, whatever it may be. So that's definitely something you're going to want to know. If my guy loses, that my insurance company is paying for loses, how much am I going to have to fit out to get out of this? And even if we settle, how much am I as a business owner going to have to pay to settle this reasonably and amicably and make everyone happy and go away?
So that's an important part. So every business owner and every person who buys a business, they worry about the cost, right? And they shop on price. And you don't know how good a lawyer is until you need one. You don't know how good your doctor is until you find out they're not any good, right?
Mm-hmm.
So that applies to a business broker, right? If it gets done easily, you think it's just magic. It's not. But if you've gone through a lawsuit or been deeply involved in it, when you get into understand that it's business. The lawyers are conducting business, and it's designed to create stress. That's the way the process is designed, right? It's the old Al Pacino. It's not about justice, right? I don't even know the line, but I think the issue that I'm trying to point out is that business owners need to take the time to read the policies in light of actions that are happening and go back and ask those questions. Who's the lawyer that defends this when we go, right? What's their record? What's the terms of payout, right? And what am I on the hook for? And before you sign for an insurance, you need to probably ask a business attorney that you have on your freaking cell phone, hey, what kind of policy what are the questions I need to be asking? Spend that couple $100, have that conversation for half an hour. So when you go in and shop your insurance policies, run it by your attorney on the backside so you have the right policy. So when something goes wrong, you're standing up and ready. It's similar. I talked to a CPA the other day about PPP, and she was like, you're all crying about it now, but you can't get enough money to fund your business, but you beat Uncle Sam because you didn't report your proper payroll, right? There's no beating it. The system's designed. You just have to know how the system works and navigate. Right. And you can't, as a business owner, know everything. That's why there's functionals, there's legals. That's why big corporations have chief counsel, right? Who make legal decisions based upon the overall health of the business. And small business owners need to have attorneys on speed dial, because stuff happens. The longer you're in business, the more hurricanes happen, the more car accidents because you have employees on the road, the more if you own a restaurant, someone chokes on something, and your cook in the back room should have known CPR. I mean, this is the level of the arguments that get made to allow the thing to continue and operate. And judges, this is the funny thing, right? Business owners, when they do get to trial, think, well, the judge will just throw it out. That doesn't happen right away. And they don't know why, right? They're like, what do you mean? It's patently stupid. Well, yes, but that judge is measured by, how he gets measured, if it gets appealed, and he wants to give everybody the ability to, restate their case multiple times, which means suits can take 4, 5, 6, 7 years before they ever get settled. And
Yeah. Yeah, absolutely. Another point to make is, not only are judges elected, so that plays a factor, but also there's an overwhelming majority of case law in Florida that cases need to be settled on their merits. Now, you may think that it doesn't have any merit, and it may not. But the threshold for what is meritorious and what is frivolous is kind of a fine line.
yep.
I've seen articles written about it's called a 57-105 motion is the legal shorthand for it, but essentially it's a motion that states to the court that this filing or this pleading or what have you is such without merit that it rises to the level of frivolous, and I've seen it used properly, very rarely.
I won that case. I won on that.
Did you? Okay.
Yeah.
Well,
And the funny thing is, this is where I discovered the system. Was I won. I was awarded fees, but then the lawyer got to litigate the awarding of the fees. That was not, so, hey, I won. I got all my fees, but then I had to litigate to get the fees, in which case that was going to cost me. And it was, wait a second, I got to pay on top of what I've, so it's kind of like, who rigged this system? Because that case, right. True defense, right? Then the ball shifts, and it's lawyer against lawyer. The guy who's going to drag that out is the other guy because he's paying for himself to defend himself, and I'm having to pay somebody to do it. So I ended up like, all right, my insurance company paid. I washed my hands of it, 8 years of pain and suffering to find out I got nothing. Now the lawyer gets a judgment, it's on his mark, right? Everyone knows he lost. So he gets a reputation in the legal community, but nobody knows. So there are damages and there's all kinds of justice in the world. But when I figured that out, like, oh, you'll get your fees? Well, hold on a second. Not really, right? You don't really get your fees. When do you ever get your fees back?
You as the individual, very rarely. I guess in a roundabout way, if your insurance company is the one doing all the litigating, I guess you kind of get your fees that way, but you didn't have any fees that you paid out anyway.
Right, and then they're going to drop you anyways.
Right, yeah, exactly. This guy.
Right. So the point is, the cheaper thing to do is to be ahead of the curve, do the things to prepare, to look at the COVID and go, okay, how do I defend myself and keep myself safe? We can argue about whether it's right or wrong. You still got to live in the world, and the legal world doesn't change fast. Laws don't get made quickly. So,
and it's such a convoluted system sometimes. And what I mean to say is that every question that a lawyer gets can be answered with the words maybe and it depends. And that's just the size of it. There are so many variables that go into it, jurisdictional issues, judge issues, actual legal stuff. There's just so much going on that, it's important to talk to your attorneys often, and you're going to get differing opinions from differing attorneys. That's just the nature of it. Someone is going to read a clause in your policy different than a judge will, or the opposing counsel. And you can make arguments on both sides, but at the end of the day, you don't know the end outcome. So that's why I keep going back to use common sense, because that's going to be your best weapon to protect yourself as a business owner, is if you made these common sense steps. Now, no one can say you do this and you're going to completely mitigate all your losses and mitigate all your exposure. No. That's just not the type of world that we live in. That said, common sense, using things that are easily identifiable are going to help you as a business owner stay ahead of the curve.
Right, and business owners oftentimes think in like a binary world. It's like, if I do X, it does Y, because their transactions work that way. And this component of the business operation is something that it doesn't sit right. Like when you find out that you don't, it's not justice. It's a crappy system, but it's the best system there is, given
Right.
there's people involved, and that there's bad, and you know, we can gripe about, you know, the jokes that people say about lawyers, but that's why you absolutely positively, no matter the size of your company, need to have a relationship with an attorney. Because, and by the way, that's not your divorce attorney, because that person's world isn't something different, right? If you own a business, your divorce attorney may have taken a contract class or a business law class, but they don't, right? You don't get taught how to practice law. You get taught the law in law school, right?
Right.
So you know, the Swiss Army knife attorney sitting in the kiosk who's doing immigration, tax law, contract, and, you know, patents, probably not the package you want. You know, it's not uncommon to operate in two spheres because they're related, but you know, you need to, if you're a restaurateur, you need to have someone who's familiar with real estate law and someone who's familiar with business law, and insurance law, because, or, you know, related cases, because that's where the risk sits, right?
Yeah, you're absolutely right.
Done with my diatribe, right?
Well, keep on it. I enjoyed it. I'm sure everyone else does as well. But no, you're absolutely right. Insurance, business, real estate. I mean, I would even throw in employment there as well. And I'll use that kind of as a new segue to go into our next point. I don't know how many of the viewers out there are familiar with the FMLA, the Family Medical Leave Act. Most small businesses don't have to know about it, right? Because before the administrative order, I forget which one it is. I think it came out in March. Before that, the FMLA only really applied to businesses that had 50 or more employees within a 75-mile geographical location of all of their offices, right? So small to mid-sized businesses aren't really thinking anything about that. So now we have this administrative executive order that was signed in that states any business with less than 500 employees now has to adhere to this new FMLA expansion. I believe it was the Coronavirus Expansion Act. Anyway, I forget the term. You Google it. And essentially, that is going to change the world for small and mid-sized business owners because of that kind of broad strokes. If you have less than 50 employees, you didn't have to worry about it. Now you do. And I believe when it first came out, the Department of Labor was sending out kind of guidelines almost daily on what it means and how to fluctuate. Now, of course, there's going to be some wiggle room for those businesses that didn't have the 50 or more employees beforehand. But it's the same standard that they would have had if they did have the 50. And it's basically if adhering to this would have been substantially prejudicial to the business, right?
Yeah, so let me kind of just, for the, if a business owner is watching this, right? Not only have you, so basically this is not, now you have to be able to pay for people who are sick and on leave, right? And we're watching businesses crumble right now, particularly the restaurant sector, because they only carry 30 days worth of reserves, right? So this massive edict goes out, wasn't thought through, because they just, you know, it was written by lawyers, and they go, well, how much working capital does a small business carry on hand? They didn't call anybody and go, what's the average? And certainly didn't ask me. I would have said 30 days. And the average company's got 10 employees or 5 employees. Okay, how many days of payroll I got to pay this guy? How does the business cash flow? So the disruption that's indicative of that edict is, you know, you said it changed the world. No, but you're the first person to bring it up, right? You're the first person to go, hey, this happened. Has anyone thought about it? Everyone's like, oh, being sensitive. And I'm like, holy crap. Now, I was thinking about our call today and the PPP, and you and I talked before the call about business owners need to protect themselves from their employees, and they need to protect themselves from their customers because of the potential liabilities. And I had a friend of mine who's a franchise lawyer. He goes, employees are your biggest threats sometimes, which nobody wants to say. But I've seen employees get into fights and arguments, and just, I was, hired an attorney, and the attorney just sued, and it was it was painful for the business owner. So, well,
Yeah.
common sense don't cut it only, bro. It goes a little deeper.
Well, yes. I mean, you're going to ultimately always have those situations where you have employees who are going to try to take advantage of the employer. That's just, it happens, and there are avenues that they can take to do that, to kind of get a hand up on the employer. But what I tell my business clients, and maybe I should, maybe I shouldn't, is, when it comes to firing or terminating an employee, because that's ultimately the larger majority of your claims. A guy got in a fight and you fired him.
Yep.
But when it comes to those types of claims, an employer can do whatever the employer wants when it comes to terminating, so long as they have not broken any laws.
Right.
Now, there are federal laws, state laws, county laws, city ordinances that you all have to be aware of, depending on where your business is operating out of and in. That said, that is something that goes just a touch beyond common sense. And when that happens, you always want to have everything documented. I can't stress enough how important it is to document. Now, if someone got in a fist fight in front of a grease fire or grease trap or whatever in a restaurant, you're probably going to be completely justified in terminating that guy.
Right.
But you better make sure that another incident very similar didn't happen and you didn't fire anybody, because now you've got a potentially discrimination issue. So always document. I used to handle employment matters for the plaintiff side, and I had an employer on the other side who actually documented everything. And this former client had told me, an exemplary employee, there was never any issues. And then I get their employment file and just see how much documented that was there. And I just look at it and I can't get past this.
Yeah, I'm done. Yeah, right. So some of my past careers, I worked in union shops. So, miserable places to work because you can't have relationships, but it was just the contract. And we literally would carry, and it was a Teamster shop in New York. So guess who we were dealing with? We were dealing with the mob. It was John Gotti's union. And we carried a copy of the contract in our back pocket. And it was the simplest thing to do. You didn't do they wrote their own demise basically by agreeing to a contract. And I always tell people, and this is my position, my brother's a union person for the teachers union, like, hey, if the bottom line is the contract's the contract, I'll just follow the contract and I'll win, right? And I don't want to tell, and I get a lot of European clients who come in from like England, for example, and the labor laws there are brutal. And they're like, can I fire somebody? I go, look, A, I'm not a lawyer. Here's my disclaimer. B, but it's a right to work state. You have the right to run your business. Now, what that means is you can't be a jerk. You got to follow the law, treat people with respect, and document. But you can fire someone tomorrow. You have to run the business. But I was discussing with someone the other day, I said, no smart business owner wants to discriminately just hire and fire people, because that's not sustainable, right? This isn't 1925 in the coal mines where we've got people living in company camps, right? This is, I want to have a good environment, but I'm not going to be held hostage by the employees. And Florida is one of those states where it's a good place to conduct business because you can run your business and not be held captive by the labor. And, what I do find with employers or business owners is they get creative. Like if we've watched it live in the last 45 days where someone, hey, you can't deliver, survival instincts kick in, you figure it out. what I'm taking away is this is like, look, just like you have a CPA, everyone goes to their accountant once a year. I think it should be more than that. Um, just like you have a, hopefully I want to talk to your business broker at least once a year, right? But I try and encourage them to talk to their tribe of other people and understand like that talking to an attorney can provide. And to make the link, like there's a real threat with this virus with regard to your business, not because they've shut you down. There's just this detrimental effect from the effects of lawsuits. And there are going to be certain types of businesses and scenarios that are targeted. It's going to happen. It's already started. You watched it on 60 Minutes. I mean, it was good. We scheduled this call the other day, and then Sunday night, the 60 Minutes thing came up. And why 60 Minutes? Because they're the biggest, right? And they got the deepest pockets. So they got a big dot on the back of their head. And it's like, you guys aren't doing your PPE. We've got the old poor labor movement story. And there's always more to the picture. But, document, anticipate. And that's where the lawyer can really help you. You guys can anticipate what the play is from the other side. There's that attorney in town who goes, I was on their side. I'm like, oh, so you play both sides, right? But there's some validity to that, is that you have to understand how the enemy behaves and prepare your defense. My old soldier piece kicking in.
Absolutely.
So you're going to go into some force majeure stuff.
Yeah, sure. So I think, and therefore I am, sorry. I think very soon we could see an uptick in some contractual litigations revolving around force majeure, specifically the contracts that are being formed now. And probably within the next 6 to 12 months, and maybe a little bit longer, depending on how long, our new normal, if you will, continues. And here's what I mean. To briefly explain, force majeure basically is the act of God. Something that neither party could possibly anticipate when they drafted this contract, and as a result, the contract cannot be fulfilled. It's a way to mitigate and limit damages for both parties or all parties, however many parties to the contract you have. But here's the issue now. So we are in a pandemic. We are currently in one. We're going to be in one for quite a little bit longer, it seems. Every day it seems like it's going to be longer. So now it comes to a point where you can't just have a boilerplate force majeure clause, or at least you shouldn't, in my opinion, that just says force majeure, act of God, whatever. You may want to specifically delineate, potential issues. That said, if you are able to delineate that issue, such as a pandemic, it's probably not so far-fetched to keep it outside the realm. So you're going to want to have clauses within your contract to kind of map out what happens in these type of situations. Because the force majeure, again, is basically, it was so unforeseen that no one could have anticipated it. Well, now we can. We're living in it.
Right. And that goes to our conversation earlier about, through my lawsuit, how the insurance company said bye-bye afterwards, because now I'm a perceived risk. Same reason, a teenager who's 17, who's got a DUI conviction, is going to have really exorbitant, right, insurance rates, because the insurance companies are doing their job of making money. Right or wrong, it's like you're predictably going to have a problem. Now the case is going to be made like, look, we've had a pandemic. It's not the first time. We just had one. You should have known. That's going to be the argument. And so everybody needs to go look at their insurance policies and go see what's in there, because it's very possible we could have another one right after this. And,
right.
And the case is going to be, you should have fixed it.
Right. Absolutely. You knew about it. There's certainly a strong argument that it's foreseeable now. So absolutely. A lot of insurance policies, excuse me, have, you were talking about attorneys saying business interruption claims for your insurance. Yep. Well, now the way that the contract really is worded is up for interpretation. I didn't think it was up for interpretation until I started seeing these ads and then reading a little bit more on it. You, in order to claim a business interruption, you have to have a sustained loss to the property. Now, before the pandemic, a sustained loss was basically someone drove a car through the restaurant. That's a loss. Now you're going to have this business interruption claim. But now the argument is becoming, well, you sustained a loss because you were shut down. And you weren't shut down because you wanted to shut down. Something physically happened. You had an actionable loss. And so now it's trying to open up these business interruption claims. That said, there's also contracts that specifically have pandemic exclusions. So that's something you're going to want to be mindful of. Because even if you call some of the lawyers that are advertising business interruption claims and you try to find one, you get an updated version of your policy and it's, oh, yep, there's a pandemic exclusion that they added in as an addendum in March of 2020.
And that once a year or biannual mailer, it's like this big and nobody reads it, but they fulfill their obligation to telling you, right? So that's how this goes down, and then they go, and then everybody's shocked, right?
Right.
Like, who actually reads their health insurance policies? I do because I'm a whack job, but or you do because you're a lawyer, right? But we all know we get these mailings and updates for our auto insurance, and everyone just gets them in the mail and they throw them out, and no one.
They open it up. Oh, hey, not a bill. I don't know any more money. Toss it or shred it if you have one. But yeah, you're absolutely right. They just have to notify you of this new addendum, this new rider, that it changes the terms, and they may cut a little bit off of deductible and have to. Again, it kind of depends on what type of insurance provider that you have. Some are better than others for obvious reasons. That said, sometimes the bigger isn't the better, but they're more covered in the event that something like this happens. I've heard, I can't recall where it was, but somebody was reporting that if every business interruption claim that could be claimed, whether or not it has any feasibility or not, was actually claimed, it would all but bankrupt the entire insurance industry for commercial insurance policies.
No, that's true.
And it makes a lot of sense. How many people own businesses that don't, or couldn't operate, even if it's a couple $100s here and there. Well, now we've got that, but we've also got your attorney fee shifting statute here in Florida, which basically says if you sue your insurance company and you win, your attorney's fees are paid. So, and that's I used to handle PIP litigation, and I don't know if you know anything about that, but you're talking pennies of lawsuits. I worked on one that was as little as $7 owed, allegedly. And if you win, all your attorney's fees, which could be thousands and thousands of dollars. So you can't just think oh, well, it's a couple $100. Well, it's a couple $100 plus thousands and thousands, hundreds of thousands in attorney's fees that is potentially.
Right, so when we're standing there, we got the billboard and such got me X, read the fine print on the bottom of the billboard. It's not what you think it is. But I have spoken to a couple of years ago, I met an attorney, one of the larger personal injury attorneys in town, and he was scared to death of tort reform. Like, this is, and on the down low in his office going, it's going to happen because of what you just said, that it's been the egregious awards have almost been, like, my father was a physician, right? And the amount of insurance as an anesthesiologist he carried, because guess what? He signed every chart. First doctor you see is the anesthesiologist. First doctor you see on the way out is the anesthesiologist. It doesn't matter whether the surgeon screwed up. Everybody's getting sued because that's about pressure, right? And I would, I'm vaguely familiar of the amount of litigate. He had one suit in 40 years of practice, and you just kind of go, how the hell? But his insurance was brutal. It got to a point he just said, I've had enough. I've had enough of paying to protect myself because my industry is being attacked. And then eventually what'll happen, because Doctors don't make what they made in the 70s and the 80s and the 90s. There's not enough meat on the bone. The natural predator instinct, it'll shift. And then they'll look to what the next avenue of approach is, which is why you see Amazon on 60 Minutes on a Friday or Sunday
Right.
night. Like, who's got the deepest pockets? It's why someone is smart to attack my firm, right? Except I've got an in-house counsel and we've kind of set a tone and our stuff's tight, right? But it's because, hey, they're bigger, right? There's more meat to feed on. It's that predatory, which is why as you get more and more successful, you need to do the basic business practices and talk to good attorneys on the front end so you're prepared for those things when they occur. You know, follow procedures, follow processes, anticipate the next change, right? Meet with corporate counsel. You should have an attorney on retainer, pay him the freaking monthly fee, because when you need them, you know,
You need them.
You don't have time to shop, right? It's like,
No.
I need to fire this guy. This is what he did. How do I cover my ass? This is what you do, right?
Right.
Do it. Don't whine about it. Yes, it's a pain in the ass. Yes, you shouldn't have to, but I shouldn't be 30 pounds overweight and I should eat better, right? But that's the life. So, thanks, Bobby. What else? What final wisdom do you impart to small business owners?
Well, I think probably some of the best advice I can give outside of common sense and all the pandemic stuff that we've talked about, just plain old-fashioned employment advice. If you have an employee handbook, follow it. And what I mean by that is, you know, we all know we're a right-to-work state, and the employer can fire indiscriminately, you know, if they want to, for any reason, whatever reason. But if you have an employee handbook and you don't follow that handbook, that is not something you want to do. It's not going to look good. It's going to be an argument for, you know, pretext. Any excuse you give later on for why you fired this person, justifiable as it may be. Say you have a 3 write-up warning. You know, you get 1 write-up, 2 write-up, whatever, and you don't do that. You didn't do it. You just fired them. Well, you better hope that they can't claim anything in Title VII or any other type of you know, local and city ordinances that they could.
I can give you a real case. There's a guy in town who had a business. He had a 1099 employee. He had a handbook. The laws changed. He didn't update the handbook. So he followed the law as it was prior to the handbook, and it basically cost him his business. And she was a Title IX. And she was pregnant. And a minority. I mean, he hit the trifecta. And it didn't matter that he was a minority.
Right.
So what we're referring to is lawyers make cases. You have a case, right? Your failure to act and to follow the policies. The handbook doesn't solve it. The handbook has to be reviewed every year to make sure it's consistent with the law, because the law has changed. It's not the 10 Commandments. Part of the body of law, right? Just like the Magna Carta, right? We've gone through this evolution of centuries. Laws change every day. And that particular circumstance, if anybody wants to know, call me. I will tell you what I can about the vagaries of what went down. But the EEOC is this body that they have to meet their numbers, and they go after small business owners all the time. So, you know, get counsel, have counsel, someone like Bobby. He's not expensive. He's going to give you wise business advice as it relates to covering. He's not going to run your business. He's going to tell you, hey, here's the information you need to know. Here's how you act. And, you know, he's telling you get a handbook. You damn well better update the damn handbook every year, or making sure it's consistent. Because that's as bad as not following the damn handbook, right?
Exactly.
It's just as it's the laws change, right? There were things that were laws that weren't good, right? We've had laws in the United States that weren't good laws, right? And those of us living in the South need to know that, right? So, you know, stuff changes every month. So where can people get a hold of you?
Sure. My website is www.leanonmelaw.com. My office phone number.
Lean on. You have like a sound playing, right?
Yeah, exactly, exactly. You know, I've looked into having that play in the background. There are some copyright issues that haven't worked out yet.
Right.
My office number is 407-502-0053. My email address is bobby@leanonmelaw.com. Happy to help, happy to discuss anything that faces small businesses and what's going on in your world.
And Bobby also is a fantastic cook, and he will share his recipes with you. He's got a whole quarantine chef portfolio. You should put that in like a book and sell that.
I like it. I like it. Some of my culinary friends have posted, well, your plating looks quite pedestrian.
Yes, yes.
Yeah, well, it tastes delicious.
All right, man. I'm going to save this and send it out.